Have you ever served on a jury? Or are you one of those people that is just waiting to get the card so you can come up with a bunch of excuses to get out of it? The premise of being tried by a jury of our peers is foundational in the US criminal justice system, and we put a ton of faith in our people to get it right. I'm so excited for our episode today and to listen to our guest as you're going to hear and be surprised by how much research and science helps facilitate the way that legal teams approach jury selection and craft their messaging during a trial. Make sure to stay tuned for the entire episode as we're going to explore how the same strategies for jury consulting may help you in your personal and your professional lives.
This is the Truth Be Told podcast, where we unlock the secrets of strategic communication. Are you ready to unlock the truth at Elite Training Days 2025, happening October 14th through 16th at Rivers Casino in Des Plaines, Illinois, where strategy, science, and storytelling come together for the premier event in investigative interviewing? Dive into cutting-edge sessions on constructive confrontation, recognizing resistance, wrongful convictions, leadership, communication, and the power of language. This event is open to interviewers across all industries: corporate, law enforcement, human resources, and anyone tasked with having difficult conversations. Register now and save $50 with early bird pricing extended through June 30th. Visit certifiedyinterviewer.com to find out more.
Our guest today is Natalie Gordon, Ph.D., a consultant at Juror with extensive experience navigating complex civil and white-collar criminal litigation. She's been involved in everything from jury selection to jury research and concept development. Natalie's an expert on cases involving significant pretrial publicity and has contributed to some pretty impressive matters, such as the U.S. versus Senator Robert Menendez, the SEC versus AT&T, Sean Rad, the founder of Tinder, versus IAC, and Monster Energy versus Bang Energy. With a Ph.D. in Psych and Law featuring a dual specialization in basic and applied social psychology from John Jay College of Criminal Justice, Natalie combines deep theoretical knowledge with practical application. She also holds a Bachelor of Arts degree in Psychology and Philosophy from the University of California in Santa Barbara and a master's degree in Experimental Psychology from the University of Colorado. With a couple of familiar names and faces to the podcast, Dr. Elizabeth Loftus from earlier in season 2 is actually Natalie's academic grandmother, which is a more fun way of saying it was her advisor's advisor. And Dr. Saul Casson was also on her dissertation panel. And speaking of her dissertation, Natalie's project, funded by the National Science Foundation, investigated jurors' perception of their fairness and impartiality of the context in pretrial publicity. This impactful research earned her City University of New York's Presidential Prize for Public Communication. In addition to her consultancy work, Natalie serves as an adjunct professor at John Jay College, where she teaches courses in psych and law, social psychology, cognitive psychology, and research methods, where she can share her expertise and passion really from the intersection of psychology and the legal system. We're so excited to have Natalie join us today. Stay tuned for the whole episode because we're going to talk about not only the science and research behind jury selection and trial preparation, but how that type of strategy and preparation and the foundational research can impact how you operate in both your personal and professional. Welcome to this episode of Truth Be Told podcast. I'm here with my friend Natalie Gordon. How are you today?
I'm doing well. How are you, Dave?
I'm good. I know our listeners just learned a little bit about your background, but probably have no idea what jury consulting is. So I want to talk a little bit about that. And I have to tell you, so I think we talked about this before, but my grandfather was a judge, and I kind of grew up sitting in the courtroom as a little dude, but also hearing this quote all the time was that the justice system is basically 12 people picking which attorney they like better. And I'm just wondering how much you feel like that's true in all your research that you found.
Oh gosh, it depends who I'm talking to. No, I'm just
Yeah.
kidding. I would say that it's certainly more than that. They actually really care about the evidence, which is something I've had now verified from the work that I do and
Yeah,
taught
I'm
others.
excited to dive into that. I saw another quote earlier, and I was kind of prepping for this that we're putting our fate into the hands of 12 people who weren't smart enough to get out of jury duty. I've also seen that. So But
Oh my gosh. Well, I hope that at the end of this, maybe some of your listeners will have more faith in the jury system than I think some who have never served jury duty before. I find that's often the case. If
I'm
you've served
sure.
on a jury, you actually have a lot of respect for the process and respect for your fellow jurors. But if you haven't, you sort of think it's this thing you're trying to get out of.
Yeah, and that's what I'm excited to talk to you about is to get into the science behind it and the psychology behind kind of jurors' perceptions of what's going on in the courtroom. And I think most people, if they haven't served, that means they're getting their perspective from watching TV. So you can probably
Right.
debunk some of that. But how would you explain, I guess, your role or what jury consulting is, especially to somebody with maybe no legal background whatsoever?
Yeah. So my background is in psychology. I'm a psychologist. And so what I do as a jury consultant is help attorneys think from a psychological perspective about how jurors will view a case. And so a lot of what I do is research. Sometimes that research is specific to a particular case, which would involve a focus group or a mock trial. Other times that research has nothing to do with a particular case. It's more about themes that would be likely to come up across a variety of case types. For example, free speech arguments, which could arise in anything from copyright and trademark infringement to defamation and social media regulation. Or it's a survey looking at attitudes, examining just attitudes about maybe pharmaceutical companies or tech companies and looking at how that varies across different venues. So it's a lot of research and helping attorneys use that research to inform trial strategy.
Yeah, it's neat. There's a common denominator through whether it's criminal or civil cases. I'm sure it's really just people's perspective. How, I know probably the one show that you would get compared to all the time was Bull. If
Yes.
people haven't seen it, but what do you think are some myths out there about what jury consultants can actually do or look at versus what the reality is of that role?
I think the main thing has to do with nonverbal behavior. It's the same thing that we know from research and psychology on trying to identify people who are lying, is that people have these misconceptions about what are reliable indicators of lying. And first of all, it's so difficult to operationalize lying. But, the tells that we think are actually indicative or reliable really aren't. And so I'm not looking at how someone's body language is per se. We're interested in what people say and how they say it and their backgrounds and their experiences. But I think there's no doubt that there's a lot of expectations that come from what people learn about in the media about what jury duty entails and what a case is going to involve. And, there's something called the CSI effect where jurors have expectations about what kind of scientific evidence they're going to be presented with and how it's going to look. But a lot of those aren't based in reality.
So you're not measuring like the blood pressure and the temperature of each person that's sitting in the jury box.
No, 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 that would be an interesting thing to do, though.
Right. I'm sure. Well, I'm glad you brought up the behavior piece. I think almost every episode somehow that's gotten tied into communication where people misread physical behavior, not even misread it, but misclassify what that behavior is indicative of. I would imagine there's people that have to report for jury duty and are having a bad day or don't want to be there for other reasons, or they're a true crime fanatic and they can't wait to be a part of that. But there's got to be a lot of other reasons that people's behaviors are off versus their dislike or like of the attorney questioning them.
Absolutely. We've all had bad days, and sometimes we bring that energy into the whatever situation, whether it's work or you're out with friends or you're with your partner, and it doesn't necessarily mean that you don't want to specifically be there. So there could be a variety of reasons that a juror might seem unhappy to be in that situation. So
Right.
there's so many reasons we don't want to read into that too much. It's always more than just how they seem to be how they appear nonverbally.
Yeah, I've even experienced that in like instructing a class, and I know you teaching at John Jay too, and you could be teaching a group of students, or for us maybe investigators, and there's somebody in the class that looks like they can't wait to get out of that class, and they hate you, and they want nothing to do with it, and they end up being the person who gives you the best evaluation and learn the most from the program. So I mean, we misread that so often because we don't know what's going on in people's lives that day, or maybe what their norm is outside of that situation.
Absolutely. And I mean, it's also worth considering some people are just shy. They're uncomfortable being in public and being asked questions in public. Doesn't mean they don't want to be there. They just don't really want to be asked anything about themselves.
Right. So now I know we'll talk a lot about just research you've done in general terms. I know you talked about like free speech, and we could talk about a little of like the rehabilitation of a juror and that kind of concept. But outside of the generalized research, are you getting brought in? Like, when do you get brought in by a legal team? What's the timing? Do they notice, hey, it's going to be a jury trial. Let's talk to somebody well ahead of time, or is it trial started? Here's our jury, and now we need some help.
It can be years in advance of trial. It could be 2 weeks in advance of trial. It could be after trial. So it's at various stages. Sometimes we get asked to do research way in advance because maybe they want to do several research exercises. They don't have a trial date yet, but they really want to put in the resources and the time to learn more about their case and trial strategy that would be effective. Other times we get brought in, right before because we're just being asked to help with jury selection, or after the fact to do post-trial interviews of jurors where it's exactly what it sounds like. We literally interview jurors after the trial has ended to learn more about how the deliberations went.
Do you feel like there's a higher percentage of legal teams starting to leverage jury consulting? Is this a growing field, I guess, or is it um, only attorneys that can fund that type of consulting, or what do you see the growth, I guess, in that space looking like?
It's an interesting question. It's hard to measure, but I mean, I think it's in some ways still a relatively young field. I mean, I'm not sure how many of your listeners are familiar with Dr. Phil, but he's sort of one of the OG jury consultants, actually. And I think it's become a bigger and bigger field. There's now an association for jury consultants. And so that's growing. More students in academia are becoming interested in jury consulting as a career path outside of becoming an academic, another way of doing applied research. But I think that something that's been fascinating to see is working on cases where there's either another co-defendant who also has their own jury consultant, or a case where the other side has a jury consultant as well. And that happens more and more these days, I could say, for sure.
Yeah, that's pretty interesting. So are you, and I know this is probably case by case is different. Are you often in the courtroom during trial?
A lot of the research that we do is outside of trial. We are sometimes involved with, jury selection. So we'll be there for the first couple days,
Right.
or a few days, depending on how long jury selection lasts. Sometimes we'll also sit in for openings and closings. The attorneys like us to be around to give them our thoughts on how it went with the jury, to look at the jurors' reactions, which, again, can be somewhat informative at times. Did someone maybe someone was struck in a particular way, and you can look into, maybe read into that a little bit. It seems like so and so, was really paying attention, or someone else seemed to be a little distracted, or so and so was dozing, right? So there might be some interest in that. The other times that we'll be around for the actual trial process would be if we run what's called a shadow jury. And so that's where you actually have a group of people that mirror the jurors seated in, across a variety of demographics as best that we can. And we interview them at the end of each day. They actually watch the trial remotely, or sometimes from the audience, but usually it's remotely nowadays. And we get feedback from them on a day-to-day basis that the attorneys can then use day to day to alter their strategy, which is really, really interesting.
That's really fascinating. That's pretty neat. So you can get some real-time feedback from hopefully a similar sample size of the real jury.
Exactly.
Yeah, that's really neat. I know we're going to dig into the science behind a lot of this, but not to simplify it, but it seems to me it's almost about crafting almost like a marketing story. I mean, you're sticking to the truth and the evidence and the facts, but it's how are you delivering that message and crafting that story? Does that sound consistent?
Yeah, I mean, the reality is it's understanding what are your case themes and which ones are going to be most effective. What is the jury going to latch on to? I mean, part of this is helping attorneys who, they're surrounded by other attorneys working on this case for often a very long period of time, and helping them sort of take a bigger picture and understand what it's like to speak to someone about that case for the very first time, and what it looks like if you were just telling a story, if you were just sort of trying to evoke the most powerful themes in that story so that people can follow you and not start, and their eyes don't start glazing over at the end of it.
Do you feel like it's a good point? Because I'm sure, just like any profession, attorneys are surrounded by other attorneys. We're all in this echo chamber. of how we've always done things. So do you ever find that there's either some resistance or some, I guess, coaching that you'll be put into where the attorney way of crafting the story based on their experience is much different than maybe what the research kind of said, the social science says, but how people are going to digest that today? Is there some conflict there, I guess, between the attorney experience and what you're bringing to the table?
I think what works out really well for us is that there's a bit of a selection bias going on. We're recruited by people who are genuinely, attorneys who are genuinely interested in what we have to say.
Right.
Obviously, sometimes, you might work with a number of attorneys, and sometimes it's actually helping them navigate the differences in opinions among those attorneys. I think they're often very, very eager to hear what our perspective is because it's different from what they bring to the table. So it's sometimes trying to figure out how best to incorporate that into their strategy.
Yeah.
But I find that they're often quite receptive to it.
That's interesting. Do you find yourself, so my only kind of relation here is doing expert witness work, where part of the difficulty a lot of times for experts is to, is to make sure you're not an advocate for one side or another. You're an advocate for whatever science or whatever your subject matter expertise is. Do you ever find that difficulty when somebody's consulting, but you're on a legal team, but your core purpose there is to make sure that it's still truth and it's still the evidence and what's the facts of the case. But does it start to blend a little bit of, are you an advocate for a side, or like, how does that, I don't know if that makes sense, but how does that kind of balance work?
Like if we feel that the way we're providing support is, advocacy per se.
Right. I mean, I guess you are, because you're being retained by one side to help craft their message. So I guess that would be the role.
Yeah, I mean, at the end of the day, we are there to help them.
Right.
Whoever
Yeah.
whoever hires us, we're there to help them hone their case as best as possible. But that's the adversarial system, right?
Right.
It's both sides are doing whatever they need to do to present their case most effectively. And the fact that there's a variety of resources that can be used nowadays, and so it's I think that consultants, at least those of us with science backgrounds, I think can bring some really effective tools to the table for them to better understand what's really going to be well received by jurors.
Right. Well, it's so important. It's very important work. It's so important to our criminal justice system and due process. I mean, a jury is the kind of the cornerstone of being judged by a jury of your peers. So making sure that they're fully educated and informed, which is some of the stuff I want to get into here, because I know there's often a gap between maybe what a juror hears versus what they really should understand, and some of the instructions they're given and some of their own biases. So I know you mentioned this before, but your part of the research is doing interviews with jurors maybe after a trial. How does that even start? What's that process look like?
So we will get asked by lawyers after a trial has ended to follow up with those jurors who sat on the case and to learn what we can about how the jury deliberated. So it's typically phone calls. I will call a juror, and the challenge with doing post-trial interviews is that you're talking to people who, for a very long time, have agreed to keep everything confidential, right? So
Right.
during trial, they start with the judge admonishing them to keep everything that they're hearing to themselves, not to do, research about the case online. And then at the end of trial, sometimes judges will request or urge them not to speak to anyone about the case even after it's ended. But barring a gag order, which would happen really just in a very high profile case, jurors can really do what they want. I mean, if they want to talk to someone, the media, whomever, they can. So the good news is it's not that we're doing anything illegal, right? You can talk to them, no problem. The problem is really that you're still sort of you're getting them to think about it differently now. They've gone from, I'm not supposed to talk about this, and do I even want to talk about it, to convincing them that there's a reason to want to talk about it. So that provides a set of challenges, and we have to be careful about how to approach jurors from the very first call.
Right. Well, let me just back up for a second. The kind of lifespan of a juror in a case, because it's interesting to talk about they've been going through this whole entire process. And I know it depends on jurisdiction, if this is a grand jury or if this is just a trial, or what the situation might be. But I mean, it starts with step one of getting something in the mail that says you're going to have to report for jury duty, call this number, show up on whatever day. And then that process you talked about, sometimes you get involved early on with jury selection. So is it is it possible that I might be a terrible juror for one case, but a perfect juror for a case next week?
I would find it hard to say that there's any case that we could be, or let me rephrase that, that there would be any case where someone wouldn't in some way be partial. And in other words, like, we all have opinions, and for some of us, they could be very strong opinions, and that wouldn't make us the best juror for that particular trial, because we want to be able to hear the evidence in an open-minded way. I will say the good news is that when you have a group of people who are deciding a case together, unless you are so latched onto your beliefs, the jury does a really good job of relying on each other's collective memory, about what was presented during trial, on persuading each other. And so I think that, unless you're really dealing with a situation of a juror who's just got such a powerful opinion that they can't be persuaded in any other way, I think you can have a group of people who, in most cases, probably would be pretty fair. But the goal is obviously to identify anyone who just has such strong beliefs that it would undermine due process for them to serve.
Right. So if I'm lucky enough to not have been struck, and I'm still on the team, or at least a backup at some point, and I end up now serving. So that's already stressful, right? Because you're being questioned by attorneys, and some of it can be personal questions about your background and your family and your professional career, those types of things. So that's a little nerve-wracking and maybe invasive for people. So now I get lucky to serve on the jury, which could be a day, could be days, could be weeks, could be months. And then that finally concludes, and I maybe have somebody's life in my hand or a financial settlement in my hand. And now you're going to call me afterwards and want me to talk about it. So that, just to put it into context, it's a good point. Is I've been maybe under kind of some anxiety for a little while of the weight on me, and been told not to talk about it. And now you want to do the exact opposite. So how do you confront that? And I'm sure some people can't wait to talk about it, but how do you confront some of that resistance with people who might be a little anxious to share?
Yeah, I mean, serving on a jury can be a very emotionally taxing experience for a variety of reasons, either because it was a very long trial and it was just a lot, took a lot of energy and time and mental effort, or because the content of the trial was in some way troubling or just difficult to process, and difficult decision to make. So one of the things I do when I contact jurors is, first I immediately let them know I'm not affiliated with the media,
Right.
which is actually very important and very comforting for them to hear. The second thing I do is I let them know I just want to ask them some questions. We can talk for as little or long as they like, and that they can answer whatever they're comfortable answering. I find that once people start talking, they don't want to shut up. It's actually really nice that once they get comfortable and realize that you're not trying to mess with them, that you're just interested in what they have to say, that you're actually just there to listen, it can actually be very, I mean, maybe cathartic is too strong of a
Sure.
word, but a really meaningful experience for them. Because again, once they realize, oh my God, I've had to keep all of this to myself, now here's someone who's interested in what I have to say outside of other jurors, I think that they can be very comfortable sharing. It's just, you want to set it up in a way that they feel safe.
Yeah, well, I have to imagine, especially depending how long they've been serving for, they probably need to talk to somebody about what just happened because they haven't been able to share it. Or maybe they didn't feel like their voice was heard inside deliberation. So it's nice to talk to somebody about it. When in
Yeah.
that research, I'm sure there's tons of things that we could talk about that you found. But do you find a lot of consistency between jurors and maybe the same trial on what the key moments were, or key pieces of evidence or points, or do you see there's a lot of inconsistency there?
Well, so there's sort of a few things when I do post-trial interviews that I'm interested in learning more about. So one of them is how the jury deliberated, like how was the jury, what was the breakdown among the jury at the start of deliberations? Was everyone on the same page about the, verdict questions? Was there some division? Was everyone on the same page about maybe there's multiple defendants, about each of the defendants? So that's one of the pieces of this. The other piece is understanding, what key themes or issues were focused on and what wasn't focused on. So were certain themes that the attorneys were trying to evoke actually landing, and were others not landing? And so that can be really interesting. Also, their perceptions of witnesses, their perceptions of the attorneys, their thoughts about how fair or unfair maybe the judge was. Did it seem like the judge was favoring one side or the other? Was, one side with the lawyers making a lot of objections? I mean, so we're interested in so many different components. I would say, looking across different cases, those are the parallels in terms of what are the things I'm interested in learning more about. But as far as like sort of the same, like, am I hearing the same issues or responses come up? I think the thing I hear most consistently is just that they enjoyed their experience.
So then I'm picturing this almost like like an exit interview from an employee who leaves a company, and afterwards you're hearing, well, they hated the boss, or didn't feel engaged, or whatever. So do you have to compile that feedback and then provide it to the legal team, or are they part of these discussions, or what does that look like?
That's a great question. So I do these interviews one-on-one. So I will call the jurors and speak to them myself. I think that if the lawyers or anyone else was on the phone with me, it would totally undermine the goal of getting them to disclose. Because one, I would, of course, want to share with the juror that they're not just on a phone call with me.
Right.
And I think it would be really strange to pick up the phone and realize you're actually, on a three-way call, on basically a conference call. Why would they? I think it would make them feel too exposed. And I would, taking their perspective, I would want to hold that information close to my heart, because you don't feel like you're having that one-on-one, more private discussion.
Right. Have you seen attorneys change their behavior based off, like, from case to case, if you've worked with them on multiple cases, from feedback they got on, I mean, I'm picturing things just from testifying on your tone, an eye roll, a sigh after a judge overruled your objection, like those types of things. Have you seen changed behavior as a result of the feedback you give?
Truthfully, no, but that's not a bad thing. We're sort of, I mean, I'm fortunate enough to be dealing with a bit of a sort of ceiling effect, in that the attorneys I work with are already so good at what they
Okay.
do. And specifically, I mean the litigators, right? So if an attorney's gone to trial, they have that experience. They're often very good at what they do. It is very rare. I mean, I'd actually have to really think about instances where I've spoken to jurors who have said, I really didn't like that attorney, or they didn't do a good job. They are so prepared and they are so effective at trial that sometimes the feedback that the lawyers are more interested in, I mean, of course, it's nice to hear that they did a good job. I'm sure they love that. But it's often more about, how did it seem when they were up against the other side? Did it seem like one side was just more effective at maybe questioning witnesses, or were they objecting too much, and was that problematic, or not enough? So those are sort of, I think, the points that are really interesting. It's hard for me to say if I'm seeing firsthand that the lawyers are implementing it, but I know for sure that they, for them to ask us to do these kind of interviews, I think they take the feedback very seriously.
Right. Yeah, that's true. They're electing to get the feedback, so they want to adapt. What about from in those interviews? Are you also asking about how they perceived witnesses? Maybe if there was
Yes.
experts brought on, and so is that, because that, I can imagine, would be great feedback to provide either the attorneys on how to prep witnesses better going forward. But if it's an expert witness, they're going to testify in other cases. So do they ever hear any of that feedback as well?
Yeah, absolutely. I mean, I think what's really useful for the attorneys is to know what witnesses, fact or expert, were confusing. Were they credible? What points were they supposed to be explaining? What were maybe some of the goals of that person testifying? And did that land, right? Was that effectively communicated? And so I think that kind of feedback, I mean, even experts can use prep, right? It's the same thing. Once you're so used to speaking to a certain audience, like in academia, right? You're used to speaking to other academics. So it can, I think seasoned experts probably are more effective communicators, but I think it doesn't matter how many times you've gone up there. Everyone can learn a little bit from how their presentation was.
Yeah, it's nerve-wracking. And I asked that question because I've experienced the same attorneys acting much different in a deposition versus in front of either a judge or a jury, right? Because in a deposition, honestly, like they're jerks half the time, right? When on their opposing counsel, because there's nobody else in the room other than your attorney. There's no judge, there's no jury. But I've seen those same attorneys now when there's a jury, they're evaluating not the question anymore, just the question, but they're evaluating how are you treating the witness and how does that kind of dialogue look. And so I guess I'm curious in your feedback, and I know we're hopeful that jurors are well prepared and informed and looking at evidence, but how much do you think the delivery versus the substance is measured from a juror?
So in a deposition, the goals are very different than at trial. So it makes a lot of sense that the attorneys are going to have very different strategies.
Right.
At trial, the goal is to always kind of be building rapport with the jury in the background. You want to come across as likable. You want your experts or your witnesses to come across as credible, as likable. So I think it's for sure both. And there are differences between how attorneys question people on direct and on cross, but jurors are smart, right? Jurors are us. We are jurors.
Right.
We are one and
Right.
the same. And most people, I think, are they understand what's happening, before their eyes. They understand the strategies and why certain things are asked a certain way. And I think often where it feels like the issue is with the experts, meaning how they are testifying about the information that they're meant to elicit. So I think attorneys can do a good job of asking the questions. It's harder for the person who's trying to deliver the message to do it appropriately.
Yeah. And they're out of their element, right? Because an expert could be a forensic scientist or a pathologist or somebody maybe who's not used to telling a story and developing rapport with people. They're used to the science. And so there's a different venue, I'm sure, for how they communicate, how they have to
Yeah.
communicate that. Yeah, that's interesting. In those same conversations with jurors, and we talked a little bit about biases. And I want to get into kind of the focus groups and the mock trial piece that you do, but I'm curious if they're reflective at all or self-aware enough that maybe did they walk into a situation with a certain assumption or bias that maybe didn't play a role in their decision? Like, do they talk about that throughout? Hey, I showed up on day one and was thinking this, but once I got to hear this story, it changed my mind.
There have certainly been instances where jurors will say, at the beginning of trial, they were feeling a certain way, or that throughout trial, even they were sort of consistently feeling a certain way about the case, about the evidence, about both parties. And then during deliberations, you find that people can persuade others. And so that's one of the really interesting pieces, is learning about why did you change your opinions during deliberations, or why didn't you? There might be an instance where there were, two jurors who were sort of the holdouts, and it's understanding, why wouldn't they budge? And, maybe that resulted in a hung jury. And so understanding the dynamics there, it's really interesting to see how people's opinions change and what causes them to change. And I think the what is probably one of the most fascinating pieces of my job, because there's a lot to be learned there. A lot to be learned because it's about what were effective arguments. What was an effective way? You've heard something, you've maybe heard something the same way X number of times, and then finally it lands different. Or someone mentions a particular thing that you hadn't thought of before, and you kind of have this epiphany moment.
Yeah, that's really interesting. I'm trying to picture what it would be like to be a fly on the wall in the deliberation, and I guess I don't know what the percentages of how many jurors are answering your phone and actually talking to you, but if let's say you were able to talk to the full jury pool, are you able to already kind of determine who was the authoritative and the influential folks in the group just in your conversations? Like, can you kind of feel that? Because I'm sure there's some more introvert personalities. I'm sure there's some more extrovert. I'm sure there's some persuasive and there's some submissive. And so can you feel that when you're talking to the group?
Sometimes, sometimes it'll be because they've made it explicit to me. They'll say this person was doing a lot of the talking, or this was the person whose notes we relied on a lot, or this was the person who, this was the foreperson, and maybe, they had more sway in the room or something, even though they're not supposed to. I think sometimes it becomes explicit. Other times it's a little harder to gauge, again, because some people who maybe didn't talk as much during deliberations, for all I know, maybe when they're talking to me, they're just going for it, right? They have so much that they want to finally share. And maybe there's other instances where someone is, not wanting to talk as much, but they were one of the leaders of the group. So it's a little hard to always gauge correctly. And one thing I also just wanted to mention, just based on one of your earlier questions before I forget, was one of the really important things about doing these interviews is the timing. So because these trials can last so long and be emotionally taxing, if we conduct the interviews weeks later, you can imagine a lot of that information. They're probably not recalling it anymore. Right. They've had that chapter of their life closed. They're done with it for so many reasons. So we really try to conduct the interviews as close to when the trial ended as possible. And that's a really, really good way to make sure you get the most detail out of the interviews, because they're going to remember more of what happened.
Well, that's important. I wanted to kind of circle back to that, the memory piece, right? Because one is looking afterwards and trying to retroactively think, hey, this is what changed my mind, or that was important to me. We know what the research says about memory, and we got a lot of issues there already. But I'm also curious what you have found. Let's say we have a trial that lasted 6 weeks or a few months or whatever. There's been several instructions given by the judge. There's been probably a lot of things that have been said verbally, but then stricken from the record that they're not supposed to consider. But how much of that, once I hear something or once it's out in the open, it's still there, right? You still are considering it. And if I had an expert testify 6 weeks ago, am I recalling all of that? Am I relying on another juror's notes? Am I really going back and reading the transcript? So what do you see from, I guess, these longer trials that exist on people's memories, maybe limiting their ability to really give a good verdict?
I think the best answer is going to be based on what we know from science, which is that if you've got a 4-month trial, an 8-month trial, whatever, it is going to be so hard for them to recall experts that they heard from at the beginning of trial. Actually, let me take that back. What's going to be the hardest is probably the people they heard from in the middle of trial, right? They might remember, recency and primacy effects. Like they're going to remember the people they probably heard from at the beginning and the people they heard from at the end. I mean, one way to assist jurors, obviously, in remembering information is allowing them to take notes. Thankfully, that happens more and more these days. I think judges are aware of how meaningful that can be, but it's not ubiquitous. And I think that can be that can be a really big challenge for jurors. I mean, I've had instances where I've interviewed jurors and they've asked me, can I go get my notes so that I can, remember some of these names? And I'm like, over the moon, please go ahead, do whatever you need to help you remember details so that you can share them with me.
Yeah, I'm sure. And I can see the argument with notes. I mean, if they have a transcript, is helpful, of course. But I know even like investigators, when they try to write a report within an hour after an interview and they don't have good notes or a transcript, they're relying on their own memory. And you could have 2 interviewers in the same room that remember something completely different. And those details are really important, obviously, when it comes to a trial and testimony. So being able to remember, and I could also imagine there's probably some arguments between jurors on different selective memory or interpretation of memory and what somebody said 3 months ago in a trial, from people remembering it or taking notes differently on it.
I mean, there will be some differences, and those can be really, really interesting. Maybe there was a witness that was particularly compelling to them, but not someone else. There was a witness who they really liked and someone else didn't like. That can vary. Maybe they did favor one set of attorneys and not the other. But often when it comes to the actual issues in the case, it's really interesting to hear how they were all focused on a lot of the same issues. And so the division isn't necessarily about the issues, but more how they see those issues.
Do you see a lot of consistency with a shadow jury, if you have one, for what the real jury found afterwards?
Yes. That can be really interesting. I did a shadow jury a few years ago that was for a month-long trial, and we had 9 shadow jurors. And at the end of every day, they all had the same overarching feeling about the case. And they were, throughout the month, always on the same side. So there was like big picture, they were on the same page. There were, again, individual differences in terms of how they paid attention that day. Sometimes some folks are a little bit more awake and attentive than others, more compelled by what was presented that day than others. But often their attitudes can be quite aligned.
That's interesting. Well, so kind of related to the shadow jury concept is I know you mentioned earlier mock trials and focus groups. So what is that? That's outside of a case, or is that an anticipation of a case, or is that just generalized research that you're doing?
So these are case specific events.
Okay.
So it'll be, we do this before trial. Sometimes we'll do multiple focus groups and or mock trials for a particular case. And the structure of them is very different. So focus groups involve having one person, one presenter present both sides of the case. So it's meant to just be, there's not this adversarial process. It's just one person giving you a summary of both sides of the case. And then you take all those focus group participants and you divide them into different rooms. And a jury consultant like myself, a facilitator, we call ourselves also for these purposes, will go in and have a guided discussion with them. A mock trial is different in that with a mock trial, it's a lot like a real trial. So you'll have different sets of attorneys presenting the arguments and evidence for both sides. And then you'll have a set of jury instructions and a verdict form that you present to the mock jurors. So they're structurally different and the goals are different. And my approach ultimately ends up being different for how I have those facilitated discussions.
That's really neat. If it's we'll go with the mock trial side, are they often seeing everything that's going to be presented in the trial, or are you specific to, you want to see how they perceive one specific verdict question or one piece of evidence that's controversial?
So mock trials are usually 1 to 3 day events. So it's going to be, no matter how long the trial is, for them pretty much always a distilled version of the actual case. But the key issues are going to be there. So we want to make sure the same themes that would come up at trial are presented during the mock trial. We make sure that, the key pieces of evidence, key witnesses jurors can hear a little bit from. So we try to sort of give them a sample of what would be heard at trial that is going to best reflect what would happen at trial. And then the verdict form, again, sometimes we have to cut it down a little bit for the sake of time, but we make sure that the main questions are always included and that they discuss what the attorneys are going to be most interested in.
Yeah, it's fascinating to me how much work behind the scenes that people probably don't know is going into, especially high profile cases, right? I mean, if you scroll on any social right now, you're going to see the Karen Reed trial or whatever, any other trial you're going to see. And you have to assume that these kind of things are happening pre-trial or behind the scenes consistently.
It's very possible. Yeah, in a lot of cases.
Yeah, I would imagine. And so for this mock trial concept, is it almost done in the same way as testing a research hypothesis, that you're going to go and test, here's the way we want to present the story. You got some feedback and realized it wasn't received in the way you wanted. And then are you replicating that with another mock trial to craft the message differently if you have the time to do so?
So really good question. So we actually will often start with a focus group because those are more thematic exercises. The goal is to understand, really presenting stories and hearing what themes the focus group participants latched onto. So that's often like the first step in the process when possible. And again, this is totally depending on what the attorneys are able to invest in. But if possible, then we would do a mock trial. And the mock trial is then, there's the verdict form and the jurors are left to deliberate the way an actual jury would. They have the instructions, they have the verdict form, and then I go in at the end just to have like a follow-up discussion with them and probe certain issues, which I can talk more about. But the goals are sort of different, and so how they're used together can be really beautiful because that's how attorneys can, again, craft their narrative most effectively. They can understand, okay, first, what are the themes I'm most interested in? And now that I understand what those themes are that I want to be presenting to the jury, what to get rid of, what to keep, what to focus on, what to develop more. Now I know, okay, now let's try to present this with the actual jury instructions that the jurors would have to rely on. So they have the burden, they understand what legal issues they're going to be navigating and how all that aligns.
So I can see we can separate those two between the focus group and the mock trial. And so that the post survey or post interview, we'll go with the mock trial group. I want to compare that to a real juror after a trial that you're going to do an interview. And I think this relates directly to our listeners because I would imagine if I'm entering in a mock trial context, I know I'm part of some type of study, so I'm expected to be giving feedback afterwards at some point. Where in a real trial, I may not anticipate I'm going to get a call from Dr. Gordon afterwards asking me all these questions. So I'm wondering, in your approach, is one more of a scripted survey type interview and more of an organic rapport building, or do you try to generate the same conversation with both?
So it's interesting because a post-trial interview is a little bit, I wouldn't say scripted, but it's more like I have the different pieces I want to make sure I hit, case themes, how did deliberations go, perceptions of the attorneys and of the witnesses and of the judge and so forth. So I try to always hit those pieces. When it comes to a mock trial, like you said, they're ready to share. They know they're there to share. They're being paid a lot more than they would get at trial to share. And so they are, the structure ends up actually being different because when they're deliberating as a jury, I'm just watching them behind a one-way mirror. I'm not in the room with them. They know I'm there though. They know that if they say, Natalie, that I'll come in and answer their questions if they have any as best I can. We actually often don't like to answer questions. We want them to rely on each other's memory again. But so the way it'll work is while they're deliberating, I'll pay attention to the dynamics of the group and the issues that are being discussed. And then that way, when I go in afterwards for follow-up, I can talk to them about, I noticed, you didn't really talk much about this piece. Why is that? What's going on there? Why wasn't this as important for your discussions? Or, oh, I noticed, that at the beginning of the discussions, you were divided this way and you guys switched you decided differently as you started discussing the verdict questions. So understanding why their opinions changed. I'll also go in and maybe, the jury is actually the mock jury is able to be unanimous and reach agreement on each of the verdict questions, which is always the goal. We want them to do what an actual jury would typically be asked to do. I'll go in and say, okay, so you all found for this party, for this side of the case. Now I'm going to play devil's advocate. I don't tell them that, but I'm going to start asking them about some of the strong arguments for the other side and understand why those weren't compelling. And so it's listening to what they were discussing, what they weren't discussing, and noticing who was changing opinions, why they were changing opinions, and presenting arguments that maybe weren't as effectively brought up by other jurors that, the attorneys are really interested in getting feedback on. And that, they thought might be effective and maybe weren't.
Do you feel so? Because you mentioned this a couple times in that answer. How much do you think either group think or like leadership dynamics are shifting opinions? Because before, when I was asking you about like the pivot points, and you said a lot of jurors, it's the same thing that this happened is when the point finally landed with me. And in my head, I'm thinking that's when maybe there was a great answer by an expert witness or a piece of evidence shown. But could that have instead been, well, this is when one of my jury peers, he actually told the story this way and I thought about it differently. So how much of it is that where the persuasion's coming from?
There can certainly be instances where someone was like meaningfully persuaded to change their opinion. Maybe, a lot of the time people go into the deliberation room and, after a mock trial, their opinions might not be very strong. So they're in a place where they're more capable of being persuaded than might even happen at trial. I mean, it's hard to say, but you can imagine after a 1 or 2 or 3 day exercise, they might not have necessarily the strongest opinions. There's room for movement there. And so it's, sometimes they're just effectively persuaded. I think other times you do see, this movement to conform to the majority. Part of that is, look, like, it seems like everyone feels this way. Fine. Maybe I should change my opinion either because I just think I should, or, because I, think we need to move on to the next question. But then, that's where I'm able to go in and better understand, I know you ended up going with the majority, but tell me how you feel right now. Would you have done that if you didn't have to all be in agreement? Would you still be stuck to your guns? And why is that? What is the thing that you're not able to let go of?
Do you find yourself now watching, if you're watching a real trial, meaning a trial you're not a part of, but not a Judge Judy trial, like a trial, but sitting there thinking, why would the attorney ask the question that way? They should have done it this way. Or why the witness, I was just watching a clip of a police officer testify and rolling their eyes and attitude with the attorney and just this tone. And to me, it just took away from any credibility of what they were saying. But do you get that just in your non-work time when you're watching any of these clips?
I don't know that I watched too many of them. It's sort of like the expression, right? The bus driver's vacation or something like
Right.
that. In
Right.
some ways, I actually, when I was in grad school, I found it very difficult to watch like that show, The Confession Tapes on Netflix.
Right.
Very, very uncomfortable for me because of what I know about those interviews. And so I think that sometimes for pleasure, I'm not necessarily going straight to that genre of TV. I find myself kind of leaning more towards, White Lotus and Succession.
Right. Right. I can see that. Well, I mean, that's, if I watched like First 48 or some of these shows and I watch 2 minutes of an interrogation, I'm thinking, what in the world are we doing? So it can get frustrating. But I
Yeah.
asked that because I'm kind of curious. A lot of what you talk about to me seems very transferable to everyday life, whether it's personal relationships, communication, and networking, or it's in a professional setting at like a board meeting and trying to convince people to all get on the same page. So I know I'm sure the science supports that, but have you seen any of that first in your life just translate over to just how you communicate day to day?
Yeah, actually, there's like two things that I think have been the most meaningful that I've learned from this work. One of them is the importance of what's not said. So there's so much that can get read into what's not said. It can be really meaningful to sort of understand why people are focusing on certain things and not addressing others. Maybe you've shared your opinion about something, or you're trying to talk to a colleague or a partner, whoever it might be, and they're only focused on a particular part of what you're saying, but not the other part. And so it's really important to understand why that part isn't coming across. Are you not saying it in a persuasive or communicating or clear way, right? Are you not effectively communicating with the person you're speaking to? So I think that's one piece. I think the other piece is that understanding like why it is that people change their opinions. So like I think we kind of talked about this a little bit earlier, but something I find is, it can be so difficult. People will have certain opinions and they keep talking about those opinions or rather they're not willing to budge on how they feel. And maybe you're talking again with a partner or a colleague or whoever it might be. And then suddenly you have a conversation and they're like, oh, okay, I see your position more now. Like I think we've all had that moment when, I think at the very least in relationships we can relate to this point where your partner suddenly realizes, oh, this is what you meant, and now I kind of see it better. And you're like, oh my God, why did it take 4 conversations for you to
Right.
get there, right? And so I think it's so important to understand it's not that they're necessarily doing anything wrong. You're the communicator. So I think what's really, really important is to understand when jurors are communicating with each other, with lawyers, they're going to use the arguments you give them. The attorneys have to give them effective arguments so that when they go into the deliberation room, they can battle each other and they can present their best case by basically through jurors. I think in real life, when we understand who our audience is and understand what are going to be effective arguments, we can be more effective communicators.
I think that's great. I got a couple things from that. That's to ask you about because that was really good. I had one of our recent episodes. We had Jerry Williams, who's a former FBI agent, and she's fantastic, and she's also expert communicator. So she was a spokesperson for an FBI field office. Now she writes crime novels and all this cool stuff. But she said something about how communication isn't really what you say, it's what other people hear. And that just hit home with me from what you just said is sometimes we get frustrated, whether it's in personal or professional life, on how come this person is not understanding what I'm saying. Well, maybe I'm not saying it in the way that they need to be able to hear it. I think that's a really good takeaway.
Yeah.
I'm curious. One of the things I'm taking away from this as well is to know how much work, and I know we only talking for an hour, we're not even scratching the surface of the amount of research and knowledge you have in this space. But you think about how much work goes into strategy and preparation to craft a message and craft a story. And I wonder how much more people could do that in their personal life. If, even it could be an argument with a significant other, or it could be asking your boss for a raise. but having your own mock trial and your own focus group and having a group of friends that aren't just going to agree with your argument, but that you can kind of role play that and see how you can deliver the message better, might be helpful.
Yeah, absolutely. I mean, my mind inevitably goes to an extreme version of this, which I'm not sure if you're familiar with Nathan Fielder and the rehearsal,
Yeah.
that show on TV, but that's like an extreme version of
Yeah.
practicing that out. But in some ways, it sort of gets to this idea that we can do a much better job of perspective taking.
I got one more question for you in a second to wrap up, but I want to recommend people to connect with you on LinkedIn. I know you've got a lot out there, and there's a ton of research that we didn't even really get into today that you've done a lot of work in. That's fascinating to me. Everything from, you did some research on people's perceptions of free speech, but that might change whether or not it impacts their type of preferred free speech or the area in which they want to be freely speaking about, which is interesting. Um, Jury rehabilitation and seeing a juror that comes in with maybe a bias that maybe can that bias be removed or not. So there's a lot of really cool research out there. So I recommend people connect with you. But I want to give you one last opportunity to kind of wrap us up. If you had a full audience of attorneys listening now, and you wanted just to give them a one piece of advice or kind of takeaway for their career or just jury consulting awareness, what would be that golden rule you'd provide?
I think I would say, welcome the research. I think research is so fascinating. There's so much to be learned. It helps with preparing yourself for trial, you, the attorney. It helps you prepare your case, not just how you present. And it can really surprise you. I mean, I think just a really great example is I'm working on a case right now involving an email that's particularly problematic for our clients. It often happens. And the jury had a really interesting interpretation of it in a way that the lawyers hadn't thought of before. And they were like, that is interesting. That's something we could probably use. And so I think you can just find yourself surprised by what the research has to say. And I just think you'll be all the better for whatever you learn from the exercise or
Yeah.
exercises.
I love that. Make some more data-driven decisions
Yeah.
in the conversations. That's perfect. Well, thank you for spending time with me. This was enjoyable, and I'm sure our listeners got a ton out of it. And again, I'll recommend they connect with you. We'll link your LinkedIn into the show notes. So if people are driving or working out or doing whatever crazy thing you're doing while you're listening to us, you can go click in the show notes and find Natalie from there. But thanks for joining, and I appreciate everybody listening to this episode of Truth Be Told.
Oh, thanks so much, Dave. This was a lot of fun.
To help more listeners find our show, please provide us a rating, give us a follow, and share this episode with your colleagues. For the latest news and to engage with our guests, follow Truth Be Told on your favorite social media apps. And don't forget, we are available on all major platforms, including Apple, Spotify, and watch a video of this episode on YouTube. On behalf of our guests and valued sponsors, thanks again for listening to this episode of Truth Be Told.